So, anyways, he should have attacked right then. He should have just said, no, Judge, 12-11-76. The judge says, I find no good cause and support for a jury trial. Excuse me, Judge. Are you saying that Arizona Constitution, the United States Constitution, and Arizona Revised Statute 12-1176 is not an adequate finding of cause? Are you also claiming that by not giving me a jury trial, you're depriving me of my civil rights under color of state law, and that's not adequate and sufficient cause to give me a jury trial? What are you basing the insufficiency of good cause and support to withhold my lawful rights and my due process of law rights to have a jury trial? Explain, Judge. Give me facts and conclusions of law right now, or give me a jury trial. But he didn't. He's, got, testicles about the size of the head of this pin here, and no spine, and so this guy lost his house. That was it. It was toast. It's over with. And it wouldn't have had to have been. All the lawyer would have had to do was, stand up with a pair and tell the judge, we're going to see this a lot. And if you go to an unlawful detainer, don't, if you've waited so long that you screwed on everything and you go to an unlawful detainer, we've got to talk because there's certain things you should do. But first of all, 12-11-76, you get a jury trial. And there's nothing the judge can do about it. And if he doesn't give you one, if he doesn't agree to right then and there to suspend the proceedings, grant a continuance until they can get a jury, I would in open court charge him with treason. I'd just say, Judge, I am hereby charging you with treason, right here and now. And we got a lot of that pin clicking shit going on. That's going to be the only way around it. But if you get in that position, don't go through a forcible detainer without a jury trial. There's no way to win. You understand it's not possible to win because there's no trier of fact. So the presumption stands for the bank, you're nothing but a criminal at that point. You must by law lose. That's it. The judge committed felonies and treason when he didn't allow the citizen, the civilian, to have a jury. After that, once he did that, everything after that, all his decisions were correct. He just had to commit treason first to make his decisions correct. Yes, Steve?
Are you saying with the unlawful detainer that you don't have a chance even if you submit good evidence?
There's no trier of fact, Steve. There's no trier of fact. Who's going to look at the evidence?
I was just thinking it was overwhelming evidence.
But who's going to look at it? If a man says something in the woods and there's no woman around, is he still wrong?
Yes.
No, he's not, because there's no trier of fact. Only to the woman is the man wrong. So only to the jury do the facts count. Yes, it is that blatantly wrong. And you better understand this stuff, because if you don't, yes.
If denied jury trial previously, can you go back and charge with treason later?
Oh, absolutely. You can do, there's a lot of different things. You could go for a quiet tam action. You can go for vacate the judgment. You can file federally under what I was going to bring up next, 28 U.S.C. Section 1361. And 28 U.S.C. Section 1361, it's a federal statute. It can apply in state court if you force it because the state has a franchise contract with the feds. And what it says is basically it's your allowance to order the judge to follow the law. That's it. It's like We're putting it in all of our pleadings on a regular basis now. It's like, Judge, I order you to follow the law. Because then if he doesn't, then he's actually committing another felony. But it's right there on the record that he's committing a felony. And by him breaking the law, he's admitted to committing the felony. So read 28 USC section 1361. Now, one of the things that this attorney went into was the bank is really an interloper. We call them a trespasser. They can be an interloper. We'll take a good look at these words so you understand what's going on. Does everybody remember the rule that you have to use to demand the real party and interest appear? And if they're not the real party and interest, to leave? 17A, correct. Okay. Interloper, person who interferes or intermeddle into business to which they have no right, person who enter a country or place to trade without license, one who meddles in affairs which are none of his business and for which he has no responsibility, an intruder, an intermeddler. So,
That would apply to all lawyers.
would apply to an awful lot of people in an awful lot of circumstances.
Have you seen other places?
Treason. No, that's right. I was looking at trespasser. Although I like that treason thing. Trespass. An unlawful interference with one's person, property, or rights. At common law, trespass was a form of action brought to recover damages for any injury to one's person or property or relationship with another. There's several pages on trespassing. Trespass vi et armis. Trespass with force and arms. Common law action for damages for an injury committed by the defendant with direct and immediate force or violence against the plaintiff or his property. You want to add little something in my federal case, just to piss them off. But there's one called trespass on the case. The form of action at common law adapted to the recovery of damages for some injury resulting to a party from the wrongful act of another, unaccompanied by direct or immediate force, or which is the indirect or secondary consequence of defendant's act. Such action is the ancestor of the present-day action for negligence, where problems of legal and factual cause arise. Now, when we look at trespass in a civil matter, where an attorney doesn't put in notice of appearance, it is remember that book, Monroe? Did I ever give that back to you?
Yeah.
Okay. Monroe had an old copy of a book that explained it very well, and I can't remember the name of it, but it went into citations on trespassing on the case, how lawyers were not allowed to interfere with the case unless they were actually part of that case. Now, obviously the problem that we're finding anymore is the courts don't really care. They're not really demanding notices of appearance, although the law says they have to do a notice of appearance. The issue comes down to jurisdiction. We'll try and explain that so you understand why we're concerned with the notice of appearance. what does a witness do before they take the stand?
Swear in,
Why?
tell the truth, whole truth, nothing but the truth.
Why? Not what they do. Why do they do it?
Can't be under the court's jurisdiction.
For jurisdiction. In other words, if they weren't sworn in under the penalty of perjury, they could say whatever they wanted in court and not be held accountable. Because then it's just somebody talking. But by swearing them in, now they've voluntarily, not always voluntarily, but it's an accepted concept of volunteerism, that the court now has jurisdiction over them. So if they do lie, the court can punish them. The court can go after them. Does that make sense? Okay, without any kind of appearance from an attorney, the court has no jurisdiction over the attorney. That's why attorneys don't want to do it. That's why banks aren't doing it. That's why the judges are fighting us so hard on this appearance stuff. Because the lawyers, if my theory is correct, then the lawyers really aren't the attorneys for the defendants. They are debt collectors. So they don't have the right to be there. And so by not putting in an appearance, then they can trespass on the court without being held accountable. Does that make sense? Just like if a witness took the stand but was never sworn in. Do you know when they'll let a witness take a stand without being sworn in? You know when that's allowed to happen? Never. Never. So, and it's because of jurisdiction. So why can a lawyer work on a case and talk without the court having jurisdiction over him? Can't. They're just allowing it because they're trying to save the lawyers.